Remember, we don't want to do a probate if we can avoid that. But when a probate is necessary, you first have the client find the original will, and that is a process in and of itself. You have to many times gain access to a safety deposit box, or you have to turn the house upside down, and it has to be the latest version of the will. Once that's found, you have to hire an attorney. The attorney has to be licensed in the state where the client passed away, where the deceased's residency was. That takes some time. Once you hire that attorney, the attorney then has to file a petition for probate and a request to appoint whoever the executor or the personal representative is that's listed in the will. Then there's a publication of a hearing that has to be published in the newspaper several weeks in a row. And then there's an actual hearing to have that appointed. This is assuming no one has objected to that. After the personal representative is appointed, they begin gathering the assets. They begin contacting the banks and contacting life insurance to see what's out there. They start gathering assets. Many times they have to have appraisals done. They provide notice to creditors. Again, that has to be published in the newspaper. This goes on and on. The probate process is applicable for when somebody has a will. It's also applicable when somebody doesn't have a will. Most people die without a will, and a probate has to be done to move their assets to where the state says that they received them in the absence of a will. After an accounting is done, then there is a hearing on a motion to approve the order. Again, that has to be published. And of course, every state's a little bit different, but in general, that's the process that gets you up to that. You can see just from the publication notices and the accountings and the timelines. Even for a simple estate, it takes many months. For a complex estate or for an estate that owns a business or has partners, it becomes much more intensive and can last years.